Only staff can purchase. Click start broadcast.
The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. Can everybody hear me? Before we begin, I wanted to check in and make sure everyone can hear me and see the PowerPoint. If everything looks good and sounds good, can you let me know in your chat box? Is anybody chatting with me? Because I don't see anything. Look at questions, not chat. Okay. Okay, good morning, everyone. Can everybody hear me and see my PowerPoint? If you do, if everything looks and sounds good, can you let me know in your chat box, please? No one can hear it? Okay, so at least one person can hear me. Can somebody not from my office put in their chat box if they can hear me and see the PowerPoint? That would be helpful. Great. Okay, so we are going to start. Excuse me. I am Sarah Thomas. I'm the legal counsel at the Tennessee Coalition to End Domestic and Sexual Violence, and this is an overview of Title VI. Not moving. There. Okay, what is Title VI? It's a federal law which prevents any entity receiving federal money from discriminating against anyone because of race, color, or national origin. Also note that when an agency serves a number of non-English speaking persons, that it might be required to provide interpretation or translation. Language services in this case relates to national origin, and we'll talk more about this later. And I want to let you know, if you have any questions, I would appreciate it if you would wait until the end to ask me, because sometimes I will cover the material during the presentation. But if you really have a question and you can't listen to the entire webinar, go ahead and ask me in between. That would be fine too. Sorry, we're having some technical difficulties here in moving the PowerPoint. Okay, what does the law say? It says no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Okay, in this case, person means a citizen or non-citizen, documented or non-documented, corporate or individual. United States, as it relates to what the law says, includes all territories, and financial assistance includes grant-funded agencies, and we'll talk more about what financial assistance means. Also note, there is a difference between a recipient of federal assistance and a beneficiary of that assistance. So beneficiaries receive an advantage of the federal assistance, but they aren't in contract with the federal government. So for example, if an agency receives a grant to provide housing to veterans, then the recipient is the agency, but the beneficiary is the veteran. In this law, when it says subjected to discrimination under any program or entity receiving federal financial assistance, this means that the law only applies to entities that receive funding. So an aggrieved party cannot sue an individual or an employee of a program for discrimination under Title VI. Okay, this is codified in 42 U.S. Code 2000D. Also note the Department of Justice is responsible for coordinating the implementation and the enforcement of this law. So they have implemented regulations, guidelines, and directives for this law. We're trying to move the screen now. There we go. What programs are usually covered? Elementary, secondary, and higher education, healthcare, social services, and public welfare, public transportation, parks and recreation, national resources and the environment, law enforcement, housing and community development. So housing could be HUD programs, and victim service programs that receive federal funding would fall under the community development category. What is not covered? Employment. Employment is not covered except where the primary objective of federal assistance is to provide employment. So for example, if a recipient builds a temporary shelter with funds designated to provide assistance to homeless, the employment practices of the recipient with regard to the construction of that facility would not be subject to Title VI. However, if the same recipient builds the same facility with funds received through a public works program whose primary objective is to generate employment, the employment practices would be subject to Title VI. So in the former case, the program's benefit was to provide shelter. In the latter, the program's benefit was the employment of individuals to build the facility. Also, what is not covered is discrimination based on age or sex. Direct benefit programs like Social Security is also not covered. And in entities, procurement contract with the federal government is also not subject to Title VI. Okay, I said we'd talk more about what is federal financial assistance. That could be grants. It could be training, use of equipment, donations of surplus training, and other federal assistance. So for most of us nonprofits and victim service agencies, we receive financial assistance through grants. So if your agency receives $1 of federal money, then Title VI applies. Also, if you're still using the product or equipment that you bought with federal money, then you are still beholden to Title VI. Let me give you an example. So say a university received federal grants, loans, and interest subsidies, so 3 types of federal assistance from the Department of Education to construct a law school. So it's clear at the time the school was built that they received federal funding and they'd have to comply with Title VI. However, after the school is built, if that university still uses the school, it still must comply with Title VI. So even if you no longer receive federal grants or funds, but you still use the equipment or a building you constructed with those federal funds, then you're still a recipient of federal funds and you are still bound by Title VI. So the clearest way you can determine if you are a recipient of federal assistance is to determine if you voluntarily entered into a relationship with the federal government. If you choose to accept federal funds, then you assent to the regulatory power of Title VI and its regulations. Also, note that if you're an agency that's a subrecipient of federal funds, meaning you don't get your federal funds directly from the federal government, but from another agency, or you get those funds from the state who gets those funds from the federal government, then that other agency or state receives those funds from the federal government, you're still subject to Title VI. Also, if you are a direct recipient of those federal funds, but you have subrecipients, for example, you get a grant from the federal government and you contract with another agency to give that agency some of the grant funds for work it will do on your project, then you have an obligation to ensure your subrecipient complies with Title VI. Okay, what is the purpose of Title VI? Why do we care? Well, it's really to make sure that everyone has access to federally funded activities. This could be WIC, local courts, free legal services, public transportation, public parks, medical and mental health facilities provided by the federal government. The purpose is really to make sure that federal funds are not used or spent in a way that encourages, subsidizes, or results in racial discrimination. Title VI also prohibits locating facilities in any way that would limit or impede access to a federally funded service or benefit. So ask yourself, does your organization take into account where its facility is located so as not to provide an undue burden on minorities or other protected classes? Title VI also encourages the participation of minorities as members of planning committees, advisory bodies, or boards of directors for programs receiving federal funds. It prohibits discriminatory activity in a facility built in whole or part with federal funds, and it requires information and services to be in languages other than English when provided to a significant number of beneficiaries who are limited in their English speaking ability. Okay, what discriminatory activities are prohibited? In operating a federally assisted program, your agency cannot, on the basis of race, color, or national origin, either directly or through contractual means, deny program services, aids, or benefits, provide a different or inferior service, aid, or benefit, or provide a benefit in a manner different than it is provided to others. You also cannot segregate or separately treat individuals in any matter related to the receipt of any service, aid, or benefit. So the key to Title VI compliance is really equal treatment, equal access, equal rights, equal opportunities, without regard to race, color, or national origin. Okay, as an agency, you're trying to avoid disparate impact on a certain population of people. So disparate impact is when policies or programs disproportionately impact minority or low-income populations, this could give rise to a Title VI claim. For example, if you are locating landfills consistently in a highly populated African American community, this could give rise to a Title VI claim. So whether Title VI has been violated is a fact-specific inquiry. We're not going to talk a lot about how that inquiry is made, but I'm going to talk a little bit about it. So in determining whether Title VI has been violated, you'll need to consider the disparate impact. You'll consider the proportion of persons in a protected class of people who are adversely affected by a policy compared to persons not in a protected class who are adversely affected. If a higher proportion of protected class persons are affected, Title VI may be violated because there is a disparate impact. And many times, to make a case for disparate impact, the claimant has to have some sort of statistical evidence of harm. However, the examination of whether there's an actionable Title VI claim doesn't end with disparate impact. The reviewer of the claim will also have to determine the significance of the harm, whether the practice actually causes the disparate effect, whether there's a justification for the policy, and whether there are less discriminatory alternatives. So again, we're not going to go into depth here about how a Title VI claim is reviewed, but I thought it might be helpful for you to get a little taste of how a claim is reviewed or proven. But again, every inquiry into whether there is a Title VI violation is very fact-specific. Okay, what's the relationship between Title VI and LEP? LEP means Limited English Proficient. So persons who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English can be LEP. The federal government and those receiving assistance from the federal government must take reasonable steps to ensure that LEP persons have meaningful access to the programs, services, and information those programs and entities provide. So what are the reasonable steps? They can include utilizing interpreters, posting signs in Spanish, using Language Line, which is a phone service that has language services. So I work for the Tennessee Coalition. We have a legal clinic that serves immigrant victims of domestic violence because we know from our demographic data that we collect that a majority of those clients are not English speaking. We would be violating Title VI if we refused to provide any interpretation or translation for the majority of our clients. However, what if we have one client per year that speaks a very rare language? Do we have an obligation to provide legal assistance in their native language? Probably not. Now, if we could find someone on Language Line who speaks their native language or a language they can understand, that would be helpful. However, a program doesn't have to do anything and everything to accommodate a small number of people. Okay, it has to be, programs are required to take reasonable steps, not every step. Okay, what are some proactive steps to ensure compliance? Best practice number 1, distribute Title VI information. Make sure employees and the general public have information on your Title VI procedures and policies, including your complaint procedure. You can distribute this information with brochures on your website and posters and other forms of media. Best practice number 2, have a complaint process. The best practice is really to have a person in your organization assigned to be the Title VI coordinator. This person should ideally be in management, and the complaint process should really contain definite timelines for filing the complaint and responding to the complaint. The complaint should be kept by the Title VI coordinator on file and should be kept confidential. But the Title VI coordinator is really important because it should be the point person for ensuring that number 1, everyone gets trained, and number 2, that complaints are properly investigated. Here is an example of a complaint process. Complaints must be written and signed and filed within 180 calendar days of the Discriminatory Act. The complaint should really include the name, address, phone number, and other identifying information if needed, the name of the person, department agency who discriminated against you, the how, the why, and when you believed you were discriminated against, and an indication of when the complaint will be addressed. In this example, it'll be addressed in 60 calendar days. So complaints really should be written and signed. It's best for your agency to have a form that an aggrieved party can fill out asking for this information, so you don't have to interview the person to get the information. However, the aggrieved party doesn't have to be the one filling out the complaint. Someone else can fill that information out for the aggrieved party. Your complaint really needs to have time frames for investigation and for letting the aggrieved party know the results of the investigation. Best practice number 3, conduct a Title VI self-evaluation. So again, make sure your employees have been trained. New employees should be trained, and employees who have been there should really reasonably be trained every year. Make sure there's a Title VI coordinator and that you have properly evaluated any complaints. Okay, so let's do a self-evaluation. Let's determine if an employee has been appointed to serve as a Title VI coordinator for your agency. For number 2, the suggestion is that if 5% of the population in your geographical area are minorities, that you make sure minorities are represented on your advisory committee or your board. It's really a good idea to make sure there's diversity in your staff and volunteers, because that's going to help you, number 1, serve your clientele better, and will ultimately help you ensure that you meet your Title VI obligations. Number 3, there should be a written procedure for hearing and reviewing the complaints. Number 4, records should be maintained regarding all alleged cases of discrimination. And also, staff should be specifically informed about their individual rights under Title VI. A determination as to whether staff are periodically apprised of their Title VI rights should be done. Include in your contracts from your agency that they are provided without regard to race, color, sexual orientation, or national origin. Include a statement of compliance in your contracts. Prominently display Title VI posters to emphasize that you have a Title VI program and that there are complaint opportunities, and identify your Title VI coordinator in your posters. Best practice number 4, like we talked about a second ago, have a Title VI statement and put that statement in your contracts if applicable. This is our statement from the Tennessee Coalition, and it says, "It shall be against the policy of the Tennessee Coalition to End Domestic and Sexual Violence to discriminate against an individual based upon that person's race, color, or national origin. This policy applies to applicants for employment and current employees, as well as to persons receiving services from the coalition." What happens when a covered agency is not in compliance? Well, oftentimes the recipient can lose funding. There can be a withholding of payments under the contract until the recipient is in compliance. The whole contract can be terminated or suspended. Now, before these measures are taken, the Title VI office from the federal agency that you receive your funding from can provide technical assistance to help you become in compliance. However, I don't think that they are obligated to do this, so they might just stop funding you. The Civil Rights Division of the Department of Justice also has a technical assistance division, so you can also reach out to them to get some assistance from them on how to deal with these claims. Here are some resources that you might want to check out if you have more questions about Title VI. The first is the Title VI Legal Manual, and that is from the Department of Justice. Again, those are the folks that are actually administering Title VI and promulgating the regulations and the guidance on Title VI. So they would be that would be a good source of information for you. If you have any questions, please email me. I'm very accessible by email. If you have specific things that you scenarios that you want to go over with me, I'm happy to talk with you on the phone as well. Just email me and we can set up a time to talk and go over those issues. But I'm available if you have any other questions. If you have any questions right now, you can go ahead and type those in your chat box, and I'm happy to respond to those. So I'll just wait a second and see if anybody has some burning questions on Title VI. Okay, it looks like nobody has any burning questions. So if you do think of any questions, please email me. I am happy to talk to anybody. So thank you so much for tuning in today, and we appreciate you. Have a good day.